if you filed that possession order on the first day that you could, which would be the 1st of March, if you got your possession date with a possession date before the 1st of May, I would be surprised. That would be really good. Once you've got that possession date, you've then got to apply to court for a county court bailiff to attend to effect the eviction. Well, again, a landlord will have done very well to have got that eviction date before the summer, before the end of July. If the landlord has done that, they will have done well. And probably I would say it'd be more like September with the current court system. So even as it stands with the certainty of no fault evictions, you're looking at 9 months to get your order. Currently, we tend to say to clients, use Section 21 because there's a little bit more certainty in it. But they still, at the moment, can use Section 8. In other words, a fault or have grounds for repossession. The issue there is, again, of course, you are reliant on getting a court date. You serve your notice, and it might be for rent arrears. You, as it stands, and this might go up, and under the new regime, I suspect it probably will. If you've got a certain amount of rent arrears, you can seek... you can go and seek possession.
They've been talking, haven't they, that at the moment you've got to have 8 weeks or 2 months arrears. They're talking about that goes up to 3 months.
Yeah.
So you can see that's going to be an issue.
But just going back to that guy who wants to sell his property, or that person who wants to sell their property, they can use the Section 8 grounds at the moment and serve the required notice period and then start the court process. You're going to have you have to get a judge to agree that that is what you're going to do, and it can be contested. You say you're going to use it because you're going to develop the land if you've got planning permission. If you are going to sell the property, they'll want a certain amount of evidence of that intention, sales particulars perhaps, or confirmation that an estate agent has been instructed. It can take...
That seems fair, that seems reasonable. And it's fair to say, isn't it, that at the moment, under Section 8, you issue your proceedings, you end up with a first hearing. That rarely gets matters dealt with. And the problem is that under Section 8, you've got both mandatory grounds, which if you can get into it, you might get possession on your first order, on your first hearing. But if you don't have a mandatory ground, you're on discretionary grounds. Then that means you're going down to trial, doesn't it?
Yeah, I mean, judges rightly, want to be convinced that a family does need to be, or a tenant does need to be evicted from their property or have the property which they are living repossessed. And they will take some convincing. But if there is something like mould and a complaint is formally raised, that there's a positive duty within quite strict time limits for the landlord to come out and fix that situation. That should be the case as well, I think, in the private sector. Landlords, if they are making the money on renting out a private accommodation, it needs to be habitable. They need to be sorting out things like mould and carbon monoxide and all of those things, because people do deserve to live in a house that's not going to cause them injury or death. And I think that's got to be the sort of the first obligation, and for that to actually work.